I think it's going to be interesting to see if the receiver, if the information that has been brought by the defendants in their motion and if the receiver's report lines up. See, the question is, where's the communication breakdown? Does the receiver, is he actually trying to help the SEC? Was there a reason the SEC appointed him who's in Florida versus in Utah? These are the questions that we're going to have to answer as we move through the next few videos watching the case between the SEC and the D.E.B.T Counsel. Hey, my name is Troy Dooley. I'm the Beachside CEO. I want to read this disclaimer. Most of you guys know I've got to read this anytime that I'm covering something of such a magnitude. This is due to my own indiscretions, my own screw-ups. But due to my SEC settlement in 2013 regarding the Zeke Rewards case, which includes me personally as well as my company, Deep South Companies, my attorney, Kevin Thompson of the law firm Thompson Burton in Nashville, Tennessee, has drafted the following disclaimer before I begin. I want to make it clear that I am not affiliated in any capacity with digital licensing, aka the D.E.B.T, the D.E.B.T Counsel, or any of the defendants or relief defendants. Not as an employee, not as a consultant, not as an advisor. This video is for informational purposes only and should not be construed as an endorsement of the businesses or the business models questioned in the SEC complaint. I'm in no position to verify or refute any claims that anyone may make in the comments now or in the future. I also want to bring you up to date. On the 27th, the SEC filed their opposition to the request that the TRO be thrown out. The D.E.B.T Counsel now has till Monday the 2nd to respond, and then there will be a hearing on this on October 6th. And what seemed like just hours, it was a few days, after the defendants filed their motion to throw out the receiver, throw out the TRO, the receiver on 9/13 filed his first report. You have to file a report on I think it's a monthly basis is what it is. So he filed his report, and it's interesting because as he files some stuff, I think it's interesting to hear what he says. He says, as described within, the receiver and his team of attorneys and professionals have undergone extensive efforts in 6 weeks since appointed to identify, marshal, and secure information and assets belonging to the receivership entities. The scope of the work has been expansive, encompassing real-world and digital assets located in multiple jurisdictions within and outside the United States, and numerous related parties purportedly acting in a variety of industries. It's interesting that he uses the word purportedly here because it seems if you've gone to all the work that you should know, and yet he's leaving some vagueness there. He's leaving himself a way out. These efforts have been aided in part by the cooperation of certain defendants, relief defendants, and third parties. We'll see how that goes. However, several defendants, primarily the D.E.B.T Counsel control persons, Jason Anderson, Jacob Anderson, Schad Brannon, and Roydon Nelson, the D.E.B.T Counsel, have failed to cooperate with the receivership's teams. Efforts or otherwise fully comply with the TRO. This is interesting here because if you guys watch the video that I did on the actual defendants saying throw out the receiver, they're saying that he's not cooperating with them. He's not communicating with them. So where's the breakdown? Because both parties have attorneys that are supposed to be talking to each other. They're supposed to be working together. And the defendants claim that the receiver's really working as a secret agent for the SEC and that he's not doing his part as the executor of the receivership assets, which is supposed to be protecting all of the node holders in this case. So it's interesting to see this. And you guys have seen what I said in the other videos. I believe this has now become a war between one of the most prestigious law firms in New York and this up-and-coming budding SEC litigation team out of Provo. Out of Utah. They want to be able to prove what they're doing and who they are. That's not bad on either case. If you look at the big law firm, a lot of their attorneys are former SEC attorneys. So it does make sense. You want to fight. You want to do what's best. The SEC is fighting on behalf of we the people. That's the premise. And the defendant's attorneys are fighting for what's best for the D.E.B.T Counsel. I mean, at the end of the day, that's what these guys do. But the receiver is supposed to be kind of a non-biased. His only focus should be to protect the assets. And I'm questioning in what you see. This is where this comes up. You question, Well, is the receiver's report totally legit, or is the defendant's motion legit? Is there something in between? Where's it at? And that's why we do these videos on this. I want to get down to what the operation is today. They've engaged attorneys and professionals to carry out the day-to-day business. He hired Holland and Knight to represent him. He got local counsels in several jurisdictions. He got accounting and asset tracing professionals and a board-certified oil, gas, and mineral law expert. They were able to establish the debtboxreceiver.com with a special website, email, and phone number. They're receiving, reviewing, and responding to numerous contacts through above channels. They secured the website Digital Commodity House and Digital Licensing Inc. And are redirecting them to the receiver's entity. But this is interesting here. The debt counsel defendants have failed to turn over control of the debt box to the receiver, the primary nexus through which debt box license holders interact with the debt box business. Well, that's very interesting, probably because they'd already moved the controlling assets offshore. There's nothing wrong with that, but that's probably why they're saying, I don't know, they're saying you're not getting it. They're establishing fiat and digital asset accounts for the receivership entities. This is the frustrating part. They shouldn't have to do that. They should just be able to take control and just take care of that. That would be the best thing. Look, there may be laws why they can't, but when it's crypto, when you're set up like you are, you really need to be able to take and do that, especially when it's liquidity pools and stuff, when there's boatloads of tax ramification for shutting accounts, moving over accounts. It's going to be frustrating. They're identifying several other fiat and digital asset accounts owned, managed, or otherwise controlled by the receivership entities, including several $1 million in digital assets located in the United Arab Emirates. Now this one, I want to say something here. If the report that we have read if the motion that we've read from the defendants is legit, those assets are no longer under the jurisdiction of the SEC, the United States, or the receiver. If in reality they move those assets to a new entity out of the UAE, whether I like this or not, those assets are now over there. Now it's a whole different ballgame. Now you're going to have to file in the UAE under UAE laws with a UAE entity, and you're going to have to prove to that court why those assets should be transferred back for a purported crime in the United States. That's a whole different ballgame I've seen that happen in others. Sometimes they can get those assets, sometimes they can't. It all depends on where the case is going to go in the long run. That's it. They initiated tracking of funds expanded and received by the receivership entities within, by, and between known entity, fiat, and digital accounts. That means they're just checking that. They changed all the register agents of all the companies over to the receivership team. They're determining that several receivership entities and third-party conduct business or perform services from the same physical address. That's fine. That's a given. Redirecting and attempting to redirect and forward mail to the receivership team. They're identifying, reviewing, tracking various videos, social media accounts, and data repositories, cloud storage, mobile applications belonging to the receivership. Interviewing several defendants, representative of certain relief defendants, and knowledgeable third parties, and attempted to interview several current and former employees of debt. The debt box counsel declined any interviews. I can see that since they think this guy's working for the SEC. Securing cooperation from certain relief defendants and third party who voluntarily provided information and documents. Marshalling and analyzing documents and information collected to date. Researching the U.S. patent. This is interesting. To date, have not yet identified any active registered patents, trademarks, or copyrights of the receivership entities. Delivered copies of the SEC complaint to everybody that needed. Identified pending litigation. There's a lot of, according to the receiver, there's a lot of pending litigation. Researching the receivership entity's efforts to restructure or relocate operations and assets to the UAE. Assessing the receivership entity taxpayer obligations for the IRS. What else is big down here? I don't want to go too long. Assessing the potential liabilities through analyzing information of third parties. No. Oh, this identifying no less than 14 jurisdictions where the receivership entities have in good faith are believed to have property interest and filing notices of receivership. This is really good. This may validate part of what the Debt Box Counsel is saying. We had legit businesses in different countries. We had operations in different countries. This could be good. Don't know. But this is good information here to know about. Summary of witness interviews and data collection. This, you guys will be interested in this. Submit a lawyer-monitored interview with receivership team. Okay. Disclose the identities of employees, contractors, agent, and service providers to the receivership. Turn over all... wait a minute. Where are we? Let's look at this. Okay. On several occasions, the receivership team has requested these following. Submit to a lawyer-monitored interview. Disclose the identities of employees, contractors, and agents. This is interesting because on the other report filed by, or on the motion filed by the debt counsel, they said that the receiver terminated the employees, 50 of them. So this is interesting. Turn over all receivership entities, books, records, assets, equipment, and property. Again, this is very interesting because the debt counsel is saying you have this stuff, or if you'd have kept people on board, you'd have known where this stuff was, and now we've got assets that are unprotected. See, there's some communication gap here. Provide all accounts, identifying information, and current last known login credentials for every email and other communication channels. Produce a complete investor and customer list. Debt counsel's refusing this, it sounds like. As detailed more fully in the receiver's motion for contempt. We can go over that one too, but not today. For sanctions, despite repeated claims, the debt counsel defendants have provided fewer than 20 documents. Now, what's interesting here is the receiver in a minute is going to, or maybe we just didn't cover it, has literally received tens of thousands of documents, but yet less than 20 from the Debt Box Counsel. But when you're suing them, I don't know. That's an interesting one there. Moreover, certain non-party agents of the Debt Box Counsel have not produced documents or provided information to the receiver team while continuing to work on matters related to, this is interesting, so they're still working for the Debt Box Counsel. As a result, the receiver has been pressed to investigate the receivership entity's operations and use funds without the benefit of document or information from the parties. Now, this is interesting. So what he's saying is, I gathered all the cash that I could get. I got all the crypto I get, and I'm going to burn through that. But yet the Debt Box Counsel is saying, no, wait a minute. He terminated everybody that could have helped him out. See, this is why I go back and say this is a war between two legal teams is what it is. During the reporting process, the receiver team interviewed or otherwise substantially communicated with more than 30 individuals, such as certain debt box investors, lawyers representing receivership entities or parties opposed to the receivership entities in prior pending or potential litigation matters, former accountants and outside CFOs of the receivership entities. This is good news right here because that shows that the Debt Box Counsel had some accounting teams going on. They talked to cloud-based accounting software companies utilized by the receivership entities. An IT support specialist used by the receivership entities and affiliates, defined as provider. Cloud-based web platform providers are hosted or facilitated hosting. Persons knowledgeable about the sale to or takeover by the receivership entities of the debt counsel defendants of various businesses and business interests. Digital assets exchanges where the receivership entities custodied assets. Purported vendors, service providers, and third-party creditors of the receiver. This is good. Since the appointment as a receiver, has retained a vendor to collect and process more than 15,000 documents that they've received. So this is going to show that the receiver is out there aggressively looking to secure and understand a very complex situation. Although the receivership team's investigation is in its early stage, we have observed that several released defendants and non-party entities operated under one consolidated management of or control of the Debt Box Counsel. There's nothing wrong with that. That happens all the time. Let's look at what else here. Summary of the assets. Given the lack of cooperation of the D.E.B.T Counsel, the receiver has had to expand significant resources to identify many of the assets and liabilities. As noted above, the receiver has filed notices of the receivership order in various jurisdictions across the country in connection with identifying these assets. This is good right here. We requested that the D.E.B.T Counsel defendants disclose all wallet addresses as required by the receiver order. The D.E.B.T Counsel defendants disclosed 12 wallet addresses and certain centralized exchange accounts. After providing them a list of 56 additional wallet addresses, the receivership identified and associated with the receivership entity, the D.E.B.T Counsel, confirmed their ownership and control of these previously undisclosed addresses and disclosed 5 additional wallet addresses. The investigation to identify additional wallets and digital assets is ongoing. That's where a part of that's where when I read and we talked about the motion, the D.E.B.T Counsel said we're not turning over some of this stuff because this would screw everything up. Here's something you guys would be interested in. Based on the analysis, the receiver can confirm that investors provided more than $110 million in digital assets in connection with D.E.B.T licensing sales. So the company sold $110 million worth of licenses to 300,000 people. To date, the receiver has identified more than 5 million U.S. equivalent digital assets currently valued at 5 million. That's a little redundant. Presently located in various digital asset wallets related to the D.E.B.T, most of which are controlled by D.E.B.T Counsel. So 110 million, you got 5 million that these guys are controlling. More than likely, that's the liquidity pool. It could be something else. During the reporting period, the receiver established multiple secured wallets, safety, custody, and protect digital belonging to the state. To date, the D.E.B.T Counsel defendants, citing various difficulties and questions about tax consequences, have only transferred approximately 145,000 USD to the receiver. Tracing assets as more thoroughly in the Dewey Declaration. The receivership has reviewed bank records of 28 accounts. These accounts are not comprehensive. The SEC froze $5.9 million in fiat assets in bank accounts. Let's see, the receivership team. The receivership team also identified millions of dollars in fiat assets either transferred overseas or purportedly overseas for the purported overseas operations. The investigation's ongoing. Receivership provided, D.E.B.T investors provided fiat assets that were used to finance the purchase of various oil and gas assets. Another positive thing right there. We're seeing that the D.E.B.T Counsel, through the marketing that they did, legitimately bought assets. So this is showing that. This is good. The receivership notes that the receivership entity and D.E.B.T Counsel publicly describe operation and assets located overseas, including in Ghana. The receivership team is working to assess the veracity of these claims, the nature of any operation or assets in Ghana or elsewhere, including through the engagement of local counsel in these foreign jurisdictions. In connection with these efforts, the receivership team continues to search and identify any royalty interests, working interests, drilling or mining rights, etc. Okay, that's good. They also shows, this is good, a summary of real property and other asset tracing. To date, the receivership team has identified approximately $9.5 million in fiat transferred to receivership entities to escrow companies, all for the purchase of real property. So within the D.E.B.T, this isn't going out. They're saying, look, we found this was part of the receivership. There's real live assets here. This is a good thing here. Again, this may go to help support my belief that there is no fraud. They're not saying there wasn't ignorance, but it doesn't look like maybe there is fraud. Now, this is one that can be tricky. Additionally, the receiver team has identified $1 million in fiat transferred for two luxury vehicle dealers for other car purchases and services. If it's a Tesla, if it's a Ferrari, if it's a Lamborghini, if it's a Maserati, these go up in value. They don't go down in value. So that being an asset for D.E.B.T, that's not bad either. A lot of guys invest in cars. That's part of it. They've identified several million that was transferred to buy the Lazy Magnolia Brewery. Again, that's validation of what these guys had been purporting. So I'm not going to go through any more. We've been at 20 minutes. Basically, what the report is saying is that the debt box counsel is not communicating with the receiver. The receiver has said, but the debt box counsel also says the receiver's not communicating with them. It's a tit for tat is what it is. But we'll be doing a third video because now the SEC has filed their opposition to the motion to remove the TRO. We're going to figure that out. So the saga continues. We'll keep focusing on it. We'll give you guys information. Live life like it's an epic adventure. Stay dangerous, stay strong. And if you're a home-based business entrepreneur, act like it.